And here we go. Thank you.
All right, good afternoon, everyone. I'm Justin Efris, the litigation section chair for the San Fernando Valley Bar Association. Before we begin, I want to note that this is the litigation section's final webinar of 2025. So I want to wish everybody a happy Hanukkah, Merry Christmas, and a Happy New Year. We host regular webinars covering a wide range of litigation topics. And if you or someone you know may be interested in presenting a webinar next year, please feel free to get in touch with me. Our speaker today is Brent Finch, a business and real estate litigation attorney with more than 20 years of experience. His practice includes commercial and residential landlord-tenant disputes, habitability claims, real estate fraud and non-disclosure matters, and business contract and tort disputes, from pre-litigation counseling through trial and appeal. He is also a past trustee of the San Fernando Valley Bar Association, and we're especially glad to have him with us today. Brent will be speaking about the rise of landlord-tenant disputes and habitability claims. We have a wonderful turnout today. Brent, thank you so much for joining us.
Thank you for that really great introduction. Hello to all the people that I know that I can't see, that I miss very much, and all the people that I haven't met yet. I look forward to getting to know you. Yes, as Justin mentioned, our firm has handles a lot of real estate litigation matters, and recently we've been seeing a huge uptick in landlord-tenant disputes of all shapes and sizes and habitability claims that either interact with those or are separate type of matters. And we'll go into the nuts and bolts of each of those things throughout this presentation. I'm happy to be interrupted with questions, and but I do think the best process would be if there's a burning question, put it in the chat and I can answer it right away. If we could leave some time at the end for questions. And you could always email me. I'm always happy to respond to emails from any attorney on any subject that I can potentially know. I'm very good at knowing what I don't know. But my email is listed here on this first slide, bfinch@finchtetzloff.com. Um, okay, so I think it's really critical that you know a little bit about me before we get started, because all that law stuff is just kind of irrelevant. This is what really matters. So I am a diehard UCLA fan and alumnus from 1996, basketball season ticket holder. Don't pay attention to football much these days. As you can see, I got my little UCLA nomicker back there. I will say this morning I've been involved in a mediation, and our settlement judge indicated he's from USC, so I was very able to quickly blur that background. For those of you who are offended by my UCLA affiliation, we can talk about that later. But if it's USC people, you guys should thank yourselves for having such a strong football program. Um, diehard Dodgers fan, and literally diehard. Obviously, that World Series was crazy. I don't think I enjoyed it even after the final out. Um, Cal, my firstborn, is a fourth year undergrad student at Cal, majoring in political economy and global poverty, maybe headed to law school one day. And my second born daughter is a senior at Oak Park High School, hoping to attend nursing school next year and anxiously awaiting college admissions. My partner, Dave Tetzloff, by the way, was also at UCLA with me in 93 to 96. All right. So the backbone of any landlord-tenant situation is a lease, for maybe overstating the obvious. There are really two types of leases, residential and commercial. We're going to focus today on residential, but a lot of the issues that we're talking about do overlap. Um, a, a, a presentation on commercial lease disputes would be another hour, and I'm happy to maybe do that next year if needed. Um, the most common lease that we see and that we work with and that we like is the California Association of Realtors form residential lease or month-to-month agreement. It's not obviously not required that people use this form. People can customize their own leases, and they often do. Um, I would say drafter beware. The California Association of Realtors form is extremely comprehensive. It covers a lot. And if you customize your lease, you're likely to potentially leave something out that might be an essential term that will come back to haunt you later. I should say a tenancy can exist without a lease. Well, first, leases can be oral, they don't have to be written. It's strongly recommended that we have a written lease, but leases can be oral, and a tenancy can exist without any kind of oral lease agreement at all. If somebody stays at the premises for 30 days in California, that triggers a presumption of tenancy. And when you become a presumed tenant under a lease or no lease, you have significant rights. And we're gonna go through what some of those rights are because they impact obviously the landlord's rights and obligations. Oops, let me go to the next slide. Okay, the first, I think, essential element of a lease is its term. I would say typically leases are for 1 year. After the recent Palisades fires, we've seen short-term leases, and we've seen plenty of disputes arising from those short-term leases. Um, the main point I want to make here is after the expiration of the term of the lease, it automatically converts to a month-to-month tenancy. Um, I I don't know how to emphasize that enough. People sometimes assume, owners, landlords sometimes assume, okay, the lease is up and now I get my property back. That is not what happens. And getting your property back is a big focus of what we're going to be talking about today, but it involves many, many steps and procedural hurdles and notices that are required. But this is the key element of the term of a lease. When the written term ends, the lease continues as a matter of law. Okay, so how do you terminate a lease? Either during its term or after the term expires and after it converts to month. By the way, in general, I despise exclamation points, but I felt compelled to put one here. Termination of a lease requires notice. It requires notice. Um, Typically, you need to give 30 days notice if the tenants have been there for less than 1 year. If they've been there for more than 1 year, you need to give 60 days notice before you can terminate the lease. And again, at the expiration of this notice, it does not mean you get your property back. It's a similar mindset that we see a lot of, where a landlord assumes that when the notice that they timely served expires, that they just automatically can go change the locks and get their property back. You cannot. At the expiration of the notice, um, you can begin an eviction process if you have to, and obviously we'll go through a lot of those details. I would say if you know your lease is expiring and you know you don't want your tenants to stay on a month-to-month basis, it's a great idea to make sure you timely give notice either 60 days before it expires or 30 days before it expires, so the expiration of the lease and the expiration of the notice period coincide. Um, Again, to emphasize, there are no self-help evictions. You cannot change the locks or take possession without a court order, even after the lease expires and even after the notice expires. And that is perplexing to many people. And I understand it. It's a cause of major frustration that just because it's my property and I said, hey, you can have it for a year if you pay me rent. And now that year is up and I want my property back. Well, we have to go through an arduous process to get you your property back. All right, another essential element of a lease is rent. Now, in the residential context, it means monetary obligations of the tenant to the landlord, except the security deposit. So, one thing I want to mention here, and we'll go through a specific slide on utilities. Sometimes, and more often than not, in a custom lease, you will see a landlord owner sometimes say rent includes utilities. Um, I would say be very careful of that. We've seen disputes just involving utilities, and if a landlord, for example, reimburses, if the landlord pays utilities and expects the tenant to reimburse, but the tenant stops paying rent and stops paying utilities, well, then the landlord can't just say, well, I'm going to stop paying utilities moving forward, and you're going to live with your lights shut off and no power and no water and whatever. Well, then the landlord's creating an untenable, uninhabitable situation, and it's the landlord simply cannot do that. So, as we'll go over later, if utilities are part of the tenant's responsibility, then the landlord might not be stuck going out of pocket to pay for utilities and expect to get reimbursed. Okay, another essential element of a lease is a security deposit. Typically, what you see is and a security deposit really can't be more than 1 month of rent in amount. It's designed to cover material damage caused by the tenant that's beyond normal wear and tear. There are many disputes between landlords and tenants solely involving the security deposit, and they happen during and after the lease expires or is in place. Um, a landlord, an owner has an obligation to provide within 21 days after the tenant moves out, an itemized statement that shows all of the deductions that the landlord is taking from the security deposit. If the landlord does not do that within 21 days, the landlord is opening themselves up to a claim by the tenant for breach of a statute, and they will be the tenant, or excuse me, the landlord could be subject to penalties and whatnot. So the other thing is the security deposit is not supposed to be used for the last month of rent. It can be if the parties discuss that. For example, if you are going to give 30 days notice to a tenant that the lease expires in 30 days, and the landlord and the tenant have good communication, which is increasingly rare these days. Obviously, for sure, the landlord and tenant can agree that instead of me paying you rent this month, we're going to use the security deposit. I caution landlords against that because you don't want to do a final walkthrough and discover all sorts of material damage to the property and not have any money in trust in place to make repairs that you normally would have had. All right, here's where I have a specific slide on utilities. And what I did here is I just cut and paste from the California Association of Realtors lease. And this is the preferred language I like to see. It prevents disputes that we talked about reimbursement after a landlord has paid utilities and the tenant refuses to pay and what to do about it. So if the tenant has to pay for it, the landlord doesn't have to worry about the power being shut off if it's going to be the tenant's fault 9 times out of 10 for the power being shut off. So typically, the California Association of Realtors lease provides that the tenant would be responsible to directly pay for utilities. Another essential term of the lease where we see a lot of disputes is regarding maintenance. Um, and also this correlates and overlaps with another section on alterations and repairs. But just generally speaking, if something goes wrong, here's the process that's supposed to be followed. A tenant is supposed to give notice to the landlord. Hey, there's an issue. There's the roof's leaking. The landlord is supposed to very reasonably and timely investigate. Okay, I'm going to send over a roofer. The roofer has checked, and yes, there's a small leak, and then the landlord has an obligation to repair it. If the landlord refuses to make that kind of repair, the tenant cannot automatically fix it him or herself and then deduct rent, but there's a process and there's a statute actually, Civil Code Section 1942, if you guys are real excited about doing some additional legal research. If a tenant waits 30 days and a landlord still hasn't made a necessary repair, then the tenant can make the repair and then deduct the cost of those repairs from the next month's rent payment. We do see this is something that has to be procedurally followed, and notices have to go back and forth. So there needs to be a good written record. And if there's not, that opens the door to a lot of disputes and they become harder to resolve one way or the other without a clean record. All right, so pets. This one is not super complicated. Typically, pets are not allowed. Um, they can be if the and you normally a landlord and a tenant will execute a separate pet addendum. But one thing that I've seen a lot of in recent years, really following and during the pandemic, was a lot of people have licenses for their pets, either for emotional support or otherwise. Um, in that situation, and we've seen a fair amount of disputes regarding that. In that situation, pets are allowed. A landlord cannot evict a tenant because the tenant has a pet, and if that pet is properly licensed as typically emotional support. Um, I want to tell a little side story here that doesn't involve landlord-tenant issues, but it involves custody of a pet. So, um, a boyfriend and girlfriend who may or may not have been engaged, I can't remember, shall remain nameless. Um, they had a dog when they were living together. They did not have a cohabitation agreement. Um, they each had their own separate license for the dog to be able to travel with the dog on planes and whatnot. The pet was allowed under their lease because of this license. They broke up. So under the law, and this is really something that's always bothered me, pets are not considered living beings that have any kind of rights, even analogous to human beings. Rather, they're considered chattel, just pieces of property that um, there's no such thing really as a custody dispute over a pet. And so what happens is this is where possession really is 9/10 of the law. My advice to I was representing the girlfriend was to take possession of the dog and not give it back, not share it, and instead effectively negotiate a buyout of the rights to the dog. And that it's an awful to even. It was not my favorite thing to ever have to handle, but I just want to tie it back to leases. Don't just assume that this box is kind of like a meaningless one on the lease. Really give consideration to um, whether you're going to have pets and how executing a pet addendum, have full disclosure between landlord and tenant regarding licenses and the expectations. Especially in like apartment complexes, this can get really problematic with other tenants who have leases with the same landlord, but they don't have pets. And the pets, as you can imagine, have to go to the bathroom in common areas. And sometimes, oftentimes the owners don't pick up after them. And you'd be surprised, maybe not, that there are a lot of disputes that we have to try to negotiate to keep out of litigation involving, you know, pet waste. This next slide also goes back to what I was talking about with maintenance, but this is another cut and paste from the residential lease, the California Association of Realtors form. Typically, a tenant should not make any repairs or alterations without first giving notice to the landlord. The landlord needs to be reasonable and investigate and agree to make repairs that are necessary. If the landlord doesn't, the landlord opens themselves up to getting rent credited or abated. Again, there's a lot of notices that have to go back and forth. The key to all this, like with any dispute, whatever kind of lawyer you are, and whatever kind of disputes you handle, or even agreements you negotiate, a lot of this just comes down to communication, notices, a clean record, and reasonable behavior. It'd be great if I don't know if any of you are watching that show Pluribus. It's interesting, a bunch of aliens, AI take over the Earth, and they're all peaceful and loving, but that doesn't end disputes. But if everybody acted reasonable, we wouldn't have to deal with a lot of these landlord-tenant or neighbor disputes that have been on the rise. Okay, another element that we're seeing a lot of disputes arising from is entry. So once a tenant is in, moves into the property and has lived there behind closed doors, a landlord is not allowed to enter unless there's a specific reason and that and there's 24 hours written notice posted before, and there's communication from the tenant after that allows the landlord to go in. And of course, you can imagine why not. There's a lot of things that happen behind closed doors. There's a significant amount of privacy rights granted to people to do whatever they want to do in their own homes behind closed doors. A tenant cannot, you know, conduct illegal activity behind closed doors. Um, they cannot, for example, run some kind of business typically, and you can imagine we've seen everything. We've seen tenants leasing a residential property to run a whorehouse. Um, we've seen tenants renting a residential property to run like a drug house. So these things obviously tenants are doing, and they are not happy to let landlords in to investigate. But if a landlord needs to get in and gives 24-hour written notice, a tenant cannot prevent a landlord from going in. Um, that's not to say a landlord can just break down the door and go in, but this gives rise to a dispute. What I will say is if a tenant refuses entry after proper notice, it can be a material breach of the lease, and it could be grounds for the landlord to evict the tenant. And we're going to go through the unlawful detainer process in a bit. Okay, another essential element that causes a lot of disputes is assignment or subletting. Typically, the rule is, again, this is cut and paste from the lease. Subletting and assignment is not allowed without landlord's consent, prior written consent. So here's one that we're dealing with right now without naming names. A an ex-wife was the tenant, and she's living in the property with one of the kids. The ex-husband is not on the lease, is not a tenant, is non-existent. This lease is for a nicer property. Rent is many $1,000s a month. It's in a really nice area. At 3 years into the lease, tenant maybe getting back together with the ex-husband, and so wants to break the lease, but creates, we think, habitability issues. There's a water leak that you didn't fix. It caused mold, blah, blah, blah. What's happening is the ex-husband has all the money and was paying for the tenant under this lease. The ex-husband hires very expensive lawyers. The ex-husband sends a letter saying this place is uninhabitable. We're moving out. You owe us $1 million in damages. But does the ex-husband have any rights to do that? The landlords did not consent to him being a tenant. There was no assignment between the tenant and the husband. He's now alleging, after we've raised that, he's alleging that he's permitted as a guest. And there's always going to be dispute over the meaning of words like who's a guest. He's never spent a single night in the property, yet he's taking over the enforcement of lease, effective, significant lease rights. So I just want to caution you, if a lease has been subletted or assigned to somebody, and there's other people living in the house, without the landlord's prior written consent, it's going to create a lot of problems for the tenant, and it's going to create a lot of defenses for the landlord. Another example that we've seen recently, a tenant of an apartment complex, let's say it's a 10-story apartment complex in the valley, walks into the lobby and gets attacked by a dog. The dog is owned by the girlfriend of another tenant in the building. The girlfriend was not supposed to be living in the building in the apartment as a subtenant. There was no prior written consent. There was no pet addendum allowing the boyfriend, who is the tenant, to have any pets. The dog, as a side note, had some dangerous propensities. So the landlord was off the hook for this case when the tenant who got attacked by the dog was injured. And it was and she was a really sweet, nice person. This all happened on video. But the landlord was not responsible or liable. It ended up being something that got settled between the tenant and the other tenant through the other tenant's insurance somehow. Okay. My next slide's kind of one of my favorite slides. I'm not a mediator myself, but I'm a huge proponent of mediation. And I think the California Association of Realtors clause regarding mediation is something that's so important that I use it in other kinds of agreements in the business sense, outside of the real estate world, outside of landlord-tenant, certainly. What this clause provides is any dispute other than an unlawful detainer action that we'll talk about, other than something that belongs in small claims court, which is under 12,500, I believe, these days. The parties have to mediate before anybody files a lawsuit or arbitration. And if they refuse to mediate, it can be a material breach of the agreement, and it could prevent one side, the party who refuses to mediate, will not be allowed to recover their attorney's fees even if they prevail in the lawsuit that is filed. The reason I love mediation so much is, frankly, and I don't think I need to tell a lot of people in this group, and it is what it is, but our judicial system is a mess. It's so backed up that you can't get justice for 2 years. Unlawful detainers are a little bit different, and that's why they're excluded from this. We'll go through that in a minute. But I've gone recently. I've gone to case management conferences where a case was filed in early in 2025, and the trial date's not going to be till late 2027. So you're going to have a case on your docket for 2 years, and other than trying to settle it at mediation, there's no justice in our system in that scenario. Obviously, there's it's more complicated than that, but I really am a big fan of this mediation provision. Almost think that it should be a requirement before anybody files a lawsuit in any of our superior courts, but um, that's never going to be the case, unfortunately. Um, Attorney's fees. So in the typical lease, especially and definitely in the California Association of Realtors lease, attorney's fees are available to whoever wins the lawsuit between the landlord and the tenant. Um, Going back to the mediation clause, I should also say, in the context of landlords and tenants, we often have brokers involved. Okay. Um, and we also, there's the same mediation provision, by the way, exists in the California Association of Realtors purchase agreement. Disputes between buyers and sellers are largely different than disputes between landlords and tenants. For example, mainly what's at issue there is a seller has to disclose all facts that materially impact the value or desirability of the property to the buyer. Um, for the most part, a buyer and a seller have realtors, brokers involved. Brokers have a duty to do a reasonably diligent, competent visual inspection of the accessible areas of the property. But sometimes a buyer, and I've seen this recently, a buyer will sue a broker and not sue the seller. Um, there's reasons for that, but even so, does the broker have to be involved in the pre-litigation mediation under the car purchase agreement or the car lease? And the answer is sometimes yes. So when tenants have brokers that are trying to find them a lease, and this has happened more often following the fires, and you can imagine um, maybe in the Palisades, there are a lot of wealthy property owners that lost their homes and they needed quickly to find um, rental properties to get them through the next phase, which is either rebuilding or where they're going to buy their next house. And they need short-term leases and they need them fast, and they often have brokers representing them. And there are disputes absolutely between landlords and tenants in these regarding everything you would expect from a typical landlord-tenant dispute, including habitability issues, which we'll get into in a minute. Um, so the mediation demand should include the broker's participation as well, just so all the necessary parties are in and it gives the dispute a better chance of getting resolved, short of multi-party litigation. Okay, now we're going to jump into habitability, and I want to do this in the context of the landlord-tenant dispute. Um, First, in every residential lease, there is what's called the implied warranty of habitability. So there might not be a clause that says a landlord has to provide a habitable premises to the tenant, but it exists and it cannot be waived. I cited a case, in case you guys want to do more homework. It's a Supreme Court case, and it goes all through the implied warranty of habitability. But basically, a landlord has an obligation, a legal obligation. It's written, it becomes an integral part, an essential term of the lease to provide a livable um, premises that complies with health and safety laws, building and housing codes, and minimum standards for heating, water, plumbing, electricity, weatherproofing, and sanitation. In addition, there's another implied covenant, and this one is of quiet enjoyment. And what this means is a tenant has the right to possess and use the premises without interference from the landlord all the time, or people acting under the landlord's authority. A landlord cannot go in and make roof repairs on Sunday morning without notice. That would breach the quiet enjoyment. We see we see an interaction with this with in multi-unit buildings where, for example, one tenant lives above another tenant, same landlord, two different leases, obviously. And what happens when the tenant upstairs is in a rock band and has, music playing, loud music playing and dancing and stomping on the floors at all hours of the night. Upstairs tenant, excuse me, downstairs tenant complains to the landlord. Landlord has like an obligation to tell his other tenant upstairs that he needs to stop this because it's interfering with the quiet enjoyment of the other tenant. That would be, you can see how these disputes between landlords and tenants become multi-party disputes really quickly. The implied covenant of quiet enjoyment is codified under Civil Code Section 1927. In addition to the implied warranty of habitability, we have a core habitability statute, Civil Code Section 1941.1, describes the residential dwellings that would be determined to be uninhabitable if they do not have effective waterproofing and weather, if they do not have working plumbing facilities, working gas facilities, heating facilities, electrical lighting and wiring, clean and sanitary premises, adequate trash receptacles, floor stairways, and railings. These are the bullets that are expressly listed in the habitability statute. I would say what I see more often than any of these is effective waterproofing and weather protection. We're seeing a rise of tenants who are claiming there was some kind of water leak. It caused mold. The mold is toxic. It's everywhere. I am not going to pay you rent anymore. And what are you going to do about it? With that basic fact pattern, we can talk about what possibly can be done. But what the challenge to landlords when their tenants stop paying rent, and they have a reason that they stopped paying rent, and it's tied to habitability, is creating a lot of these disputes that are becoming very difficult to resolve and make it very difficult for a landlord to evict a tenant. I'm gonna have to rush through this a little bit. Sorry. Some of the defenses that we can assert on behalf of a landlord to habitability claims, things are cosmetic or minor. The tenant didn't give us notice to fix it, or the tenant did give us notice and we fixed it. They denied us access. They interfered. Really, that the tenant caused it. Like for example, in one of our current disputes, the water intrusion event that's being alleged by the tenant comes from an air conditioning unit that they put in themselves that the landlord never gave written consent for the tenant to install. That's going back a few slides. The installation of air conditioning would potentially be a material breach of a lease. And if it's causing the habitability issues, it should be a defense to the tenant's habitability claim. I say should be because these have to be fought out in court, and the court has to resolve them one way or the other. I'm now going to go through quickly uh, the lifeline and timeline of an eviction process. And the eviction lawsuit is known as unlawful detainer. The rules for unlawful detainer are codified under Code of Civil Procedure, section 1159 through 1179A. There are many twisting, turning roads throughout this entire process. I have about 13 more slides in about 10 more minutes. I'm going to rip through them, but once you get to the process where you simply cannot negotiate with your tenants anymore, they will not leave, they're not paying you rent, you absolutely have to get your property back, you need to live there, whatever reason, sometimes you cannot avoid having to evict a tenant and you have to follow very strict rules that are very difficult to follow oftentimes. Otherwise, attorneys wouldn't be necessary. The main goal of an eviction is to get possession of the property back. Unlawful detainer does allow for the recovery of limited rent that has not been paid. It typically it only goes back 12 months, and it's only what you put in the 3-day notice. When you serve a 3-day notice, we'll go through notices quickly in a minute. You need to say we're evicting you because you haven't paid this much rent in this time period. Once you file a lawsuit, discovery is limited, although you can take a deposition, you can do interrogatories. But what happens is normally trials are requested right away and they have to be set within 20 days of the request. So it's a very quick process. Before you file an unlawful detainer, you have to have personally served a sufficient legal notice. The typical notice is a 3-day notice to pay rent or quit. Another typical notice is a 3-day notice to perform an obligation under the lease. It could be to not have a pet anymore if that's the material violation. It could be to fix something that the tenant caused. It could be to stop running the whorehouse that we talked about earlier. The other notices we talked about briefly, if you want to, if there's not a breach by the tenant, but the lease is going to expire, if for a tenant who's lived there for under a year, you can serve a 30-day notice. For a tenant who's lived there more than a year, a 60-day notice. In addition, if you're trying to evict somebody, and we're going to go through this, for what's called no fault, just cause no fault, and there's certain reasons you can try to do that. You have to put those reasons and a lot of other essential elements into your notice before you serve the notice and way before you serve the unlawful detainer complaint. Okay. After an unlawful detainer complaint is filed, the tenant has a very quick time period to respond. Typically, the tenant will file an answer. The answer will include some of these affirmative defenses, if not all of them, even if they're not necessarily applicable. The main ones we've seen and have to deal with are, hey, your notice was defective. It didn't have an essential legal element that was required. Or you said I owe you $10,000 in rent. Well, I just paid you 7, and so you're not owed 10. The breach of the warranties we talked about of habitability and the covenant of quiet enjoyment are defenses. Violation of the Tenant Protection Act, which we'll go to in a minute. One of the big ones that I didn't list as a bullet point, but I have a slide on it, is retaliation. So I want to point out, if a tenant has notified a landlord that there is an alleged habitability issue with the premises, the landlord cannot say, and the tenant's not paying rent. Let's say the tenant says, I'm not paying rent in December. because there was a water leak and it caused mold and you didn't fix it. The tenant can't say, that's nonsense. You didn't pay rent. I'm serving you with a 3-day notice and I'm evicting you. And I didn't mean just because it's December and it's close to the holidays. That would be considered retaliation, even if the tenant's allegations are not true. The fact, and you can look at this closely under Civil Code Section 1942.5D. A landlord, and unfortunately we've seen this, our firm won't file one, but we've seen it on the other end, where a landlord who does try to evict a tenant who has raised a habitability issue is subject to what's called malicious prosecution, and that's bad, for lack of a better word. That can come with significant damages. Okay, I mentioned the Tenant Protection Act. So during the pandemic, we saw the whole landscape of landlord-tenant and unlawful eviction laws change, and for good reason. We didn't want people getting evicted and living on the streets during a major pandemic. So what happened generally was there was a moratorium on evictions. We don't have to go through all of that, but what happened following the expiration of the moratorium was tenants in California, our lovely state, have significant rights when they become tenants. And we've gone through some of them. It's impossible to go through all the details, but really, in short, if I could sum it up, a tenant can just stop paying rent for months and months and months and comfortably not be kicked out or evicted. And they can cite to and rely on a lot of things in the Tenant Protection Act to keep them in that property for a long time. So the normal ways to evict people are for what's called just cause. Just cause typically means non-payment of rent, or a breach of a material term of the lease. There are others, but those are the two main ones that we see. There's tenant breaches that we've seen include, hey, you keep violating the same provision of the lease even after you cure it once. Again, criminal activity or illegal use. Refusing entry by the landlord, and are few. There's a big category of evictions where the tenant's been a good tenant. Tenant's paid rent. The tenant's not caused problems. The tenant's on a month-to-month lease. The tenant's got, 6 more months on the lease. But the landlord desperately needs to live in the property or have a close family member live in the property. So there's a few processes where a landlord can evict a tenant without a tenant being at fault. And they're outlined in this Tenant Protection Act. The one that we see most often is the owner or a close family member wants or needs to live in the premises. And if that's in that situation, there's a lot of fine print. Even this slide, which cuts and pastes from the Tenant Protection Act, it's in small print, and I didn't even get a lot of it. This is where you need, I think, a lawyer to walk you through the details of how to evict. It's not easy. It is doable. And usually, hopefully, it results in a settlement, which we'll get to in a minute. Other grounds for a no-fault just cause eviction besides I want to live in the property. I want to take my property off the market. And there's a bunch of rules that have to be followed to do that. Or you're complying with the government rule that you have to do something. and or you just intend to demolish it and substantially remodel it. Again, each of these these evictions are doable. They're just very difficult and they require a lot of hurdles to jump through. When you do a no fault just cause eviction, not only do you have to give proper notices, you have to offer relocation assistance. Typically, it's 1 month of rent. That's the minimum. I'm not telling you that's going to do it. I'm just telling you that's what the minimum is you have to offer. Um, Towards the end of let's see, towards the end of an unlawful detainer case, before you get ready for trial, there's usually an opportunity, even on the day of trial, to settle the case. And the typical way to settle an unlawful detainer case is for a stipulated judgment. And there's a form. I didn't post one, but it's available. It's a judicial council form even. It's available if you Google it. It has all the necessary elements, boxes to check. But essentially, judgments entered in favor of the landlord. The landlord gets possession back. Remember, that's the key of an unlawful detainer case. Sometimes the landlord can get awarded a judgment for some of the back due rent. There's a discussion of how the security deposit is going to be applied. And importantly for tenants, because you might ask, well, why would I agree to this? The record is typically sealed. So if a tenant is going to go look for another place to live, the new landlord might not be able to see that the tenant got evicted. Now, that's up to a landlord to do a reasonably diligent investigation, due diligence of before leasing to a new tenant. But the sealing of the record is an important consideration for tenants. They usually also, just to be another reason why the tenants are inclined to enter into this kind of agreement, they know they're going to lose. They know they're going to get evicted. They don't want to get locked out. They can negotiate for an extra month or some more time to move out, and a reduction in the rent they owe. Typically, landlords are happy to just get possession back and to move on. Um, okay, I mentioned this way earlier before, but let's say you go to trial, you're a landlord, you win, you get a judgment for possession. That does not mean you get to go to the house and change the locks and you're the only person who can go in. You have to get lockout instructions. The sheriff locks out. This process takes a fair amount of time. Again, more hurdles, but the key takeaway here is there is no such thing as a self-help eviction. You cannot change the locks without a court order. Um, this is another topic for that probably would take a lot more than 2 minutes to go through, but there a lot of times with good communication, and if tenants have counsel and landlords have counsel, a lease termination agreement can be negotiated well ahead of an unlawful detainer dispute. And what you can do is you can say, you can give the tenant X amount of days to move out. You can pay them X amount of dollars to move out early. There's a lot, again, a lot of procedural hurdles and requirements, but typically you would end up paying a tenant 20,000 is kind of a rough range that we've had experience seeing these things settle for. In more expensive properties where, let's say, a landlord needs to get 4 tenants out of a building because he wants to sell the building, well, then you might have to expect to pay a lot more to each tenant. And I've seen negotiated settlements in the 6 figures. But then there's business reasons behind that typically. We already went over this a little bit, but a landlord has 21 days after the tenant moves out to return the security deposit. Typically, you can only limit deductions to material damage beyond normal wear and tear. And if rent is still unpaid after the tenant moves out, it can be deducted for that as well. That is the end of my slideshow. We're coming up on 1 o'clock. Justin, I'm not sure if we have any
We have
questions.
we have a ton of questions, Brent. Thank you for the excellent presentation, well prepared, lots of great content here. So if I can just run through some of the questions that were entered into the chat.
Sure.
Um, for security deposits, can a landlord charge 2 months rent if the property is furnished?
I think the answer to that is no. Um, I, I have to check on that specifically, but I think there's a rule that security deposits in the residential, in commercial, it can be a little more. I think it's 1 month of rent is the limit. What you can do, you can get clever with your lease and you can say security deposit is 1 month of rent, but you could also charge separately. And I've seen this more in commercial again for the last month of rent or something like that. But typically security deposits are not supposed to be more than 1 month worth of rent.
And talking about security deposits, um, if you are going to deduct expenses for damage, where do you mail that itemization to uh, so that you can get it to the tenant?
So that's a really good question. And that comes down to communication. Before your tenant moves, you need to figure out a way to get their last known address or their next known address. I would say, as a backup, try to have their email address. I'm not suggesting service of this by email is sufficient. I'm also saying it's not insufficient. If that's the only way you can get a hold of a tenant because they've left, send the itemized statement by email. Actually, before the 21 days expires, say, hey, I'm going to send you my itemized statement. What's your new address? That usually can rectify it. If they don't respond to you, send it by email. Just create a written record that you've done your diligence to try to get them the itemized statement.
And I would think if there's any money left, it might not be so hard to get an address if you ask the tenant, where should I send your check to?
Yeah, I think you can guess that more often than not, there's not any money left.
Right, exactly. Okay, and then going to the notice to end the lease, there was a question, what if the lease is exactly 1 year? Is it 30 days or 60 days?
30.
Okay. And a question I had is, can a landlord who's be cute or clever and say, here's our lease agreement and here's a notice to end the lease, like right at the beginning, so that so it's well in excess of 30 days or 60 days. Would that fly
No,
or is that just
it
too
doesn't
cheap?
fly. Because let's say you're saying you're going to give 365 days notice. Yeah, that's
Correct.
pretty cute. No, I wouldn't recommend that. I would recommend doing no more than 60 days, but doing it, even if you have a 1 year tenant, you can give like 90 days notice, maybe. Just you're being really, really diligent about it. I've seen that. Sometimes for whatever reason, you might have to give 90 days notice. My list of different notices was not exhaustive. Unfortunately, there are other specific instances where you might have to give 90 days notice. But I do, again, the best practice, I think, just comes down to communication. So if you know you're going to want the property back at the end of the lease, give way more notice and then in that 60-day period, you have a lot more time to go back and forth to try to get a deal together that ensures that they leave. And you don't have to file an unlawful detainer.
Excellent. So I thought of this question too, and someone asked it. You mentioned that there's a presumption of a lease, even if there's no written lease, if the tenant or the person is there more than 30 days.
Yep.
Um, how does the law reconcile that with the ban on unauthorized sublets or assignments? If somebody is an unauthorized tenant because they were being sublet the apartment, and the landlord doesn't know about it, does that person have those significant tenant rights? Or is it more like adverse possession where the landlord has to know that they're there?
So the landlord should be should know who's living in the premises, but oftentimes doesn't. Where this issue comes up, the presumed tenancy is actually in the Airbnb VRBO situation,
Hmm.
where you sign somebody up for like a 15-day Airbnb, but they end up staying 30 days and they paid you. Um, all of a sudden they become presumed tenants of your place, and you have to kick them out. Um, the squatter situation is another one, and I think that's what you're more or less referring to, where the landlord just hasn't been paying attention, and there's that have broken into and maybe changed the locks themselves on a place and are living there for more than 30 days without a lease, without telling anybody, obviously without paying rent, maybe paying their own utilities. That's a little bit of an adverse possession type of an analogy. In that situation, unfortunately for the landlord, there's a presumption of the tenancy, and you have to kick these people out, and it can become difficult. And that's kind of, it falls on the landlord to be more responsible for figuring out who's living in the impossible situation is, um, family members move in or become guests. Let's say there's a four-bedroom house that's being rented and there's only one tenant on the lease, but then, cousins move in or whatever. Typically, those cousins need to have written consent to be there for more than, I think it's 14 days or so as guests, typically. But if they stay for more than 30 days and the landlord hasn't done anything about it, they might be able to assert rights as tenants. The landlord might say, well, the main tenant on the lease has breached the lease, but it definitely causes complications.
Fascinating. Could
Again,
go either way, it seems.
the bottom line is tenants have significant rights, and landlords are in a really tough situation post pandemic. They just are. It used to be everybody wanted to have rental properties. Now everyone wants to get rid of their rental properties.
We have one last question and a lot of comments. Everyone here thought this was a wonderful presentation. Question about raising rent. How often can a landlord raise the rent? And are
Once a
there
year, and it typically, um, it can only be raised, I think, like 4 or 5% or something like that. There's specifics on this, and I might be mixing it up in my head with some commercial related issues as well. What we've seen too, that I'm sure people are curious about, or maybe that was part of this question, is the price gouging that's happened after the fires. You can't a landlord can't say, oh, my place is available, and then increase the rent by more than 10% of whatever its value was. That becomes illegal price gouging. I have no personal experience dealing with that kind of dispute, but I had to look into it.
Well, thank you so much. This was excellent. And maybe we'll be looking forward to having you back next year on the commercial side of things. But
You're gonna
thank
have
you
to pay a
again.
lot. You're gonna have to pay a lot more for next year. Now that I
Thank
know.
you.
Thank you.
All right, thank you.